court has said that the provision where the designated executive officer could have determined the title of a Waqf property and a consequential change in the revenue record would have made clearly violates the basic structure of the constitution, which is the separation of powers. And the court said that in this matter, the title is to be decided either by a judicial officer or by a quasi-judicial tribunal, not by a district magistrate or a designated officer. Therefore, we are staying it. Now, the problem is, one, we don't understand that Waqf is already over-regulated. You have a central law for Waqf for ages. We do not have any central law for the Hindu religious properties. We can't be going the Iran way, I believe, where you have religious policing, whether the girls have their hairs or don't have their hairs, whether they cover their head or don't cover their head, should not be the business of any state.
So now that you were saying that it's an interim order, now what are the point of arguments or the contentious arguments which are going in front of the court, and what do you expect the court to do?
I don't see this case is going to be heard anytime soon.
The recent judicial scrutiny by the Supreme Court on Waqf is being hailed by both sides, the opposition also and the ruling party also. So what are the implications of Waqf management on religious freedom and minority rights in India? To understand the nitty-gritties, I'm joined by a very distinguished guest, Professor Faizan Mustafa. Sir, thank you so much for speaking to Indian Express. He's a renowned constitutional law expert and Vice Chancellor of Chanakya National Law University in Patna. Sir, first thing that I would like to ask you is, please make us understand for a normal viewer that what did the Supreme Court say, and did the changes which have been made are good or bad?
Thank you, Neetaji. Supreme Court gave an interim order.
Yes, sir.
So it is not a final order on the constitutionality of the Wakf Amendment Bill, which has now become an Act of 2025. Number of provisions of this law were challenged by number of petitioners. A bench of 2 judges led by Chief Justice Gawai, and then the companion judge was Justice Masih, has given an unduly long interim order.
Yes, sir.
An interim order consisting of 128 pages is quite long because it is not the judgment. Now, if I can say it in the simplest terms, except for few provisions, the entire Act Court did not find prima facie unconstitutional. Because an interim order is issued only when, or a stay on a provision is made only when the court at the very outset, even before hearing the arguments on merit, considers some provision as contrary to constitution, in contravention of fundamental rights, and therefore they would say no. Even before we decide finally on this case, these provisions cannot be implemented. So the court has said that the provision where the designated executive officer could have determined the title of a Waqf property and a consequential change in the revenue record would have made clearly violates the basic structure of the constitution, which is the separation of powers. And the court said that in this matter, the title is to be decided either by a judicial officer or by a quasi-judicial tribunal, not by a district magistrate or a designated officer. Therefore, we are staying it. Similarly, they have given a temporary stay to a provision which mandated that only a person who is professing Islam for 5 years would be able to make Waqf of his own property. the court has said that till the state governments make rules in respect of this provision will also be stayed.
Okay.
Then the court diluted, or you can say, in a way, tried to address the apprehensions of the petitioners that it is one thing to say that non Muslims are going to be the members of the Central Waqf Council or the Waqf boards, but there is a possibility that in some cases, even the majority, or in the other case, at least about 50% members of these two bodies can be non-Muslims. The court said that's not right, and therefore the court fixed a specific number, which is a maximum number to which you can have non-Muslim representation in the Waqf board and the Central Waqf Council. And fourthly, the court said that we expect, the Solicitor General of India has assured us that as far as possible, the Chief Executive Officer of the Waqf Board should ideally be a Muslim. Now, other than these provisions, for rest of the provisions, the court is saying that prima facie, at the very outset, we don't find them problematic, but let the parties argue this case. So there will be a possibility when the case is finally decided, maybe some more provisions are either held unconstitutional or some of the provisions on which there is a stay right now, the court eventually finds them not problematic and upholds them.
So, which are the provisions, as per you, are really contentious? When the original Waqf, law was made. So, which were the provisions which you contested as a law student?
You see, I had appeared because the Joint Parliamentary Committee was very kind to invite me, and they heard me for almost 5.5 hours. Because of the parliamentary privileges, I cannot be divulging the details
No,
because
but as a law officer,
I'm not supposed to.
Hmm.
But I was one person who said that there are some provisions in the law which are good, and some provisions which can be defended, and some provisions should not be opposed. Like, for instance, I said that the inclusion of non Muslims in the Waqf board and the Central Waqf Council should not be opposed because we are a diverse country. We believe that the diversity of the society must be reflected in all institutions. So I said that I am not going to oppose such a provision. But there were provisions which I say as a legal academic uh, are controversial, like the one which requires that you should be practicing Islam for 5 years before you can make waqf of your own property is deeply problematic.
But that has
Because
been stayed.
what is at stake?
Hmm.
It is somebody's own property. How can you put restraints on the use of a property which belongs to a person? Because a waqf can be made only of one's own property. There is a provision which I had also welcomed, that it was always there impliedly. Now you are saying it explicitly that only an owner can create waqf. I welcome it. But if it is my property, whether I am in X religion or I am in Y religion, whether I am a good Muslim or I am a bad Muslim, whether I am having a beard and I pray 5 times a day, or I pay zakat, or I don't lie, or I am the greatest liar ever born on this earth, who never went to any mosque, but it's my property. If I want to make a waqf of my property, you can't be, questioning it. Similarly, no law, as I speak to you, Nitaji, prohibits voluntary conversion. So if somebody converts to Islam, now you cannot say that between the Muslims, there are two categories of Muslims. Those who converted in last 5 years or those who took birth in a Muslim family. This is an artificial classification. It is an arbitrary classification. Such kind of classification cannot be made because, even theologically speaking, in fact, somebody who converts to Islam is to be respected more than somebody like me who was born in a Muslim family and never had a choice in terms of which religion I would adopt because my parents and my grandparents gave me that religion. If somebody takes a voluntary decision after becoming an adult, I think he is far more a Muslim than any person who is a Muslim or a Hindu by birth. Then to put this condition on this person that you will not be able to make work of your own property for 5 years, in my opinion, is deeply problematic, and ideally the court should have stayed it.
Hmm.
Now, the court, by requiring that I should be practicing Islam for 5 years, even though the law said I must be professing Islam.
Okay.
As you know, in Article 25 of Indian Constitution, freedom of religion, it is a right to profess, practice, and propagate. So even what law did not provide, the Supreme Court judges have provided now that you should be a practicing Muslim for 5 years. I believe that this kind of a law may lead to religious policing. The state officials will pass a judgment. X is a bad Muslim, Y is a bad Muslim or a good Muslim. He should not be allowed to, create waqf of his property because he is not praying, he is not fasting, he is doing this. We can't be going the Iran way, I believe, where you have religious policing, whether the girls have their hairs or don't have their hairs, whether they cover their head or don't cover their head, should not be the business of any state.
Absolutely. Absolutely, absolutely. So when the government says that, these are reformative laws, they are reforming. So what do you have to say to their, this point of argument?
You see, law reform is an ongoing process. I have said it a number of times and written in my articles that the law reform should always be uh, not with any political motive. We can't be using law making for political purposes. I would have loved, and I had written it even today in the Indian Express, that it was an opportunity to bring a uniform civil code. Why we need to have a different law for Hindu religious places and Muslim religious places? By conceding that you want to have a law for Muslims, we are going in the opposite direction of one nation, one law campaign, or in the direction of a uniform civil code. If
Hmm.
we want a uniform civil code, this was a good opportunity for the government to bring one uniform law for all religious communities, whether it is a temple board or it is a gurdwara board or it is a church property or a mosque or a madrasa or qabristan, let all of them be governed by one common law.
So some critics also argue that the centralizing Waqf control through the Act 2025 is in conflict with the state powers and land laws. What do you have to say on that?
No, the problem is one, we don't understand that Waqf is already over regulated.
Hmm.
You have a central law for Waqf for ages. We do not have any central law for the Hindu religious properties.
Hmm.
So already there is lot of state regulation in respect of Waqf.
Hmm.
Waqf boards are not some private bodies. They are statutory authority. They are a state within the meaning of Article 12 of Indian Constitution because they come into being under the Waqf Act, which is a law passed by the Parliament. Now, if this is so, then states have been denied the right to make rules.
Hmm.
Even in respect of BNS, which is the central
Bharatiya National.
uniform criminal law for the country, states have a right to make their own provisions. Now,
Amendments.
in respect of number of entries like burials, etc., which are in the state list, states have been denied that right. So I believe that by not allowing state to make even rules under the new Waqf law, somewhere we are undermining the authority of states, and therefore it somewhat impinges on the federal ideal of our constitution.
So the debate about, the new Waqf rules, do they fairly, as compared to the women, compared to the Hindu inheritance laws also, do they fare comparely? What is the real argument behind this? I mean, people have been arguing both sides.
Waqf law is not basically about inheritance.
Hmm.
But you raised a very interesting and pertinent question, and let me tell you, I have given so many interviews to TV anchors, none of them could even
Understand.
ask this kind of question.
Hmm.
You see, in the Waqf law,
Hmm.
we are making now a provision that you cannot be so doing creating a Waqf which leads to denial of inheritance rights to women.
Hmm.
Now, at the face of it, the provision looks very good and it looks pro women. But we need to understand that if a father gives just 1 rupee and rest of the entire thing he creates waqf, there is no denial of, because there is no exclusion of women.
Hmm.
If 1 rupee is given, you can't say it is an exclusion. The other problem is, are we willing to make a similar law in the Hindu Succession Act?
Hmm.
Why we did not provide such a provision in the Uttarakhand Uniform Civil Code? Because what is the position under the Hindu Succession Act? Even though the son and daughter have been given the equal share in the property of the father, but the father has a right to give his entire property to whomsoever he wants, including the son. And that's why many Hindu fathers have told their daughters that we have given you education, we have
Yes.
married you, we have given dowry to you. Now you have no share in the property. This entire property will go to your brother. Respect your brother. Don't demand any share from your brother. And that's why the ownership, if you look at men-women ownership ratio amongst the Hindus, it is not comparable with the Hindu succession law, which is providing equal rights of inheritance. Now, unlike this, under Islamic law, a Muslim father cannot make a will either in favor of a son or in favor of a daughter. You cannot make will in favor of anybody who is your heir in natural scheme of things. You
Okay.
can make the will only of 1/3 of your property, not entire property, and that too for a stranger. So if you have taken very good care of me in my life when I was sick, if I'm going to die, I can give you 1/3 of my property, but 2/3 is to be distributed amongst the natural heirs. So, my idea is that what we are going to do and what kind of thing we are providing, it may not improve the situation on ground. On the contrary, there is evidence from Ottoman Empire where the father suspected that the son is in bad habits. Therefore, he will create the waqf of his property and appoint the daughter as the mutawalli or the manager of the property. So the brother would be dependent
On the sister.
on the daughter. Or in some cases where one of the child was a disabled child, so he said that I'm making the waqf, and out of this income, etc., this much should go to this person with disability.
So now that you were saying that it's an interim order, now what are the point of arguments or the contentious arguments which are going in front of the court, and what do you expect the court to do, the Supreme Court, because the Supreme Court is still listening to the case?
I don't see this case is going to be heard anytime soon. So we have to wait for few years. This interim order will operate. The Waqf law will be implemented. Some of the most contentious provisions have not been stayed, like Waqf by user, which in my opinion is not unique to the Waqf law. A similar provision is there in the Hindu endowment laws in number of southern states. It is a principle of evidence. This is the law which has been quoted with approval by the five-judge bench which decided the Babri Masjid judgment, by which this two-judge bench was bound. Waqf by user is a principle. What is a principle? That if my property is used by you for a long time without me raising any objection to it, then it shall be presumed that the property has become yours. Now, this routinely happens. It happens in all kinds of cases. By saying that we are abolishing Waqf by user, are we abolishing the principle of evidence? Because it is a principle of evidence. Who is in possession of property and for how long? This is a general law of the land. So I believe that the court should not have just gone by this kind of argument that so many properties in Andhra Pradesh have become the Waqf property. How does a property become a Waqf property? A survey is conducted by the public servants appointed by the state.
State. Yes.
So government officials will do the survey of the Waqf properties. In the survey, they operate like a civil court. They look at all the evidence, all the ownership documents, electricity bill, rent deed, revenue paid, etc., etc. Then, on the basis of a report of state's own government officials, when they make a recommendation to the Waqf board also has a large number of government nominees. It is a myth that it is some private land mafia body. Look at the composition of any Waqf board and you will find most of the nominees may be coming from the government or they are nominated by the government. Now they make a recommendation to the state government. So government officials conduct the survey, they make a recommendation to the Waqf board, which is already under the control of the government. Government may dismantle a Waqf board. It may dissolve a Waqf board. And then on the recommendation of the Waqf board, it is published in the state gazette that X property is a Waqf property or Y property is a Waqf property or Z property is a Waqf property. And therefore, I believe that this point required little bit more elaboration by the lawyers and more consideration from the bench because they need to look how this law will play on ground. You may be having hundreds of burial grounds of which no papers are available.
Yes.
Hundreds of mosques may be there, 700 years old, 800 years old, where people are praying for ages. They may not be having any paper. Now, if that burial ground or a mosque has not been registered and you say that this is going to be taken over by somebody, we are going to create a lot of uncertainty and unrest and possible conflict in our society.
So, like the opposition has been saying that they have been claiming victory. Do you also interpret the judgment like that only, that it has been opposition victory?
I think this is not right. If most provisions are upheld and few provisions are stayed, it can't be said as a victory. Similarly,
Thank
the
you.
government cannot say it is a victory because on some of the contentious provisions which were pointed out in the JPC by number of people who were invited and by the opposition members in the House, the government did not accept, but the court found those provisions problematic. I don't see it as a victory and defeat of anybody.
Thank you. Thank you so much, sir, for explaining a little bit of this contentious issue to the Indian Express viewers. Thank you so much.
Right? Okay, bye bye.